A preschool teacher in Georgia is accused of abusing the children she was supposed to be caring for. We're going to dig into the charges she's facing and if she has any possible defense with an Atlanta attorney who specializes in these kinds of cases. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. It seems like every week I'm talking about another teacher behaving badly with children. And here, we have a young pre-K teacher in Canton, Georgia, who is facing charges days after she was accused of injuring multiple children at Big Blue Marble Academy. So deputies arrested 21-year-old Mayme Allen on August 12th. This is after a report about incidents that happened just on that Friday, August 8th. And we'll talk about that time frame as well, because I think it's important. But Allen is charged with 3 counts of cruelty to children and 1 count of battery. And according to arrest warrants, in one instance, Allen allegedly grabbed a child by the arms repeatedly, squeezed them. The child reportedly had bruises on their arms, the backs of their shoulders. In another incident, she reportedly pushed in a child's chair, causing the child's chest to hit the table. Hey, so I want to thank Upside for sponsoring this episode of Sidebar. So Upside is a free app that gets you cash back on daily essentials like gas and groceries. So when I pump my gas, if I use Upside, I could get cash back. Real cash back. It's money that appears in your Upside app that you can transfer straight into your bank account. Once you have the Upside app, you claim an offer for whatever you're buying on Upside, like a Shell or Taco Bell. You pay as usual using a debit or credit card. You follow the steps on the app and you get paid. So to find out how much you could earn, click the link in the description to download Upside or scan the QR code on screen and use our promo code SIDEBAR and you'll get an extra 25 cents back on every gallon on your first tank of gas. That's promo code SIDEBAR for an extra 25 cents back on your first gallon of gas. Now, we don't know the ages of the alleged victims in this case, but the preschool's website says that they have daycare programs for children as young as 6 weeks and preschool programs all the way through 3 years old, and Allen was reported to be one of the teachers in that preschool program. Allen was released on $25,000 bail, and we don't have a ton of information on this, but we do have some of these details, and I want to break it down right now with Atlanta defense attorney Noah Pines. Noah, thanks so much for coming here on Sidebar. Appreciate it.
Thanks for having me.
What's your thoughts on this? For me, covering this, like I said, week in, week out, it's like another example. We just covered one recently of these daycare workers who were accused of abusing children. So now you have this teacher accused of it. What's your take on it?
Well, I think she's more of a daycare worker too, based on the age of the children. There are multiple cases like this right now in Metro Atlanta area. So Canton is in Cherokee County. It's north of Atlanta, but almost considered Metro. From my research and looking at the warrants, the ages of the children are actually 12 months, 14 months, and 16 months. Which the first question I have is, what are this woman's qualifications to be in a class with these children? And more importantly, in the state of Georgia, daycares are regulated. So if she's in class with certain children under a certain age, and whether they're walking or not depends on the student-teacher ratio, but it's either 1 to 6 or 1 to 8. So is she in a room with 6 kids unsupervised, no other person there to help, 8 kids? That's a big concern that I would have.
Let me ask you a question. You might not know the answer to this. Is there any initiative to put cameras in all of these schools or in daycare centers? Should there be a push to have that? There's one thing to talk about, maybe you don't need cameras in a high school setting, but in these kinds of settings where you have vulnerable children who can't speak for themselves, who can't defend themselves, do you think it's wise to maybe have cameras in these kinds of settings?
100%, especially if somebody's in there by themselves. If you have multiple people in there, that's one thing, but by themselves, definitely. We have my firm has a similar case. We have the civil aspect of it, but somebody was prosecuted for picking up a child, an infant, very violently, shaking the child, and in essence, slamming the child to the ground. And without that video camera, and then that worker touched a whole bunch of other children inappropriately. And without that camera, we would have no evidence of this because these kids can't speak about it. And in our case, the parents weren't even notified timely. And that's a big thing. When you have these vulnerable children, there are regulations that should be followed, and especially if they are being, only supervised by one person.
Yeah, and to be clear, in this incident, I don't know if there are cameras involved. They have that kind of evidence. But what I will tell you I think is interesting is that this incident happened on the 8th and the arrest happened on the 12th. I just covered another case about this that I think that time frame is so important because many times in abuse cases or alleged abuse cases, it can go on for a long period of time before there's an arrest. So to see that that time frame, only a matter of days, I think that's significant.
My bet would be that there is video evidence just based on the description in the warrants with the three separate victims of, how the acts were alleged to have occurred. One was squeezing, causing significant bruising to one child. One was pushing in a chair very violently, which then caused the child's chest to hit the table. And the third was, again, another chair pushing. So my bet is there is some sort of evidence, video evidence in this case.
I want to go through some of these charges with you to talk about them and what you think a potential defense could be. So when we talk about the child cruelty, any person commits the offense of cruelty to children in the first degree, and I was reading the statute here, when such person maliciously causes a child under the age of 18 cruel or excessive physical or mental pain. Any person commits the offense of cruelty to children in the second degree when such person with criminal negligence causes a child under the age of 18 cruel or excessive physical or mental pain. So there's a little bit of a distinction there between the first and the second degree. I would imagine you think that this fact pattern fits in there, right? And I guess the other question is, how do you defend against that?
Yeah, so the real question is this a felony cruelty, or is it a misdemeanor battery? So the difference in punishment is huge. A misdemeanor is punishable by up to 12 months in jail, and cruelty is a 5 to 20-year felony. There's no prison requirement, but 5 years mandatory, at least probation. So the real question is there malice? Maliciously means malice, and in Georgia, that's not defined. So it's really whatever the jury thinks. And then the next question is there cruel and excessive physical and or mental pain? So, some people would say anytime you strike a child, it's cruel and excessive. But of course, there's parental discipline and striking children happens, in every day. So the real question is, does this rise to the level of a felony, which is how I think probably the defense attorney will, who's assigned to this case, will defend it to say, well, this is bad, but it's really just a misdemeanor.
Or do they say this was an accident? Do they say I wasn't, deliberately pushing the child in? I was just trying to escort them. Unfortunately, they're vulnerable. The child got hurt. I was moving the child away for another reason. Do you see that in your practice, that these kinds of defenses, that I was trying to do my job, I wasn't being excessively physical with them, but I was doing what was needed?
Yeah, I think there's going to be some sort of I didn't mean to cause this result, but anytime when you're in charge of a child, I mean, these are Cherokee County is a conservative jurisdiction, and people aren't going to want to see any child being I'm not going to say manhandled because it's an alleged the defendant's a woman, but to be handled physically in any way. So the real question is, was the hands on the child part of being the preschool teacher, or was it something else? And so if I think if it's something else, then it's going to be real hard to have a defense of, I'm not guilty of this. I think it would be more of a mitigation. This is a misdemeanor versus a felony. For felony cruelty, you should have something more, misdemeanor battery is when you cause, insulting, provoking contact with somebody, or even cause bruising. So if I punch you in the face, you and I get in a fight and I punch you in the face, that's a misdemeanor, even if you get a black eye. Now, if you punch a child in the face, people could think that's malicious.
And that makes sense. And I would say also completely understandable. If we do treat this as a felony, and again, I could be wrong here, but I understand that with the first degree cruelty charge, it could be up to 20 years in prison. Second degree could be up to 10 years in prison. Let's say, for argument's sake, this is charged as a felony. This goes to trial. She is convicted. How often do you see a sentencing where it's on the higher end, that we really do see the double digits? Or is this more of a situation, if this is, I hate to say this, but a first-time offense, there's no history of this? Because again, I think people are trying to understand what could theoretically be the punishment if this is as bad as we think it is, and she's ultimately prosecuted to the full extent of the law.
Yeah, I could see there wanting to be a statement made. And, the statement is we don't tolerate people abusing children. So I could see, especially in Cherokee County, them recommending a prison sentence. Double digits, I don't think so. Could it be 2 to 5 years? Definitely. Um, that would be something, that would be standard up there.
Does it usually plead out, though? Do we usually see plea deals in these kinds of cases?
You would, I would go back to what are the facts? Is there video evidence? And then, if there is video evidence, how bad is it? There's a lot of times when you really have to see the video to understand how bad it is. I prosecuted child abuse cases for a long time, child homicide, child sexual abuse, and child cruelty cases. And a lot of times in the child cruelty cases, you'd want to see the pictures. We didn't have videos typically back then, but you'd want to see the pictures of the injuries to understand how bad is it. And this is, I think, one of those cases where I can read what's in the warrant, but how bad is it? Was the push of the chair a forceful push, or was it like a literal slam? Was she trying to hurt these children, or is she a 21-year-old who has no business being in charge of 6 children under the age of 2 and with no training? And I think it's going to be, that sort of a circumstances is that she should have never been, she should have never been there in that position. That's where I think 21, 22, she's young. And to be in charge of that many children is probably not a good idea. But of course, these daycares need to make money.
And I'm going to talk about that in a second, but just putting a final point on this. In your practice, in your career, did you ever have a situation where it was felony child abuse or felony cruelty to children, and you worked out a deal with the defendant where there was no prison time put on the table, even though you're talking about some egregious acts?
Yeah, so the civil case that we have, the person was prosecuted criminally, and the state in that case, the district attorney's office did recommend prison time. The defense attorney who represented the woman did a very good job of mitigation and explaining to the judge what happened, and she ended up getting a probated sentence. She got house arrest and ankle monitor, but they put on a compelling story for the judge where prison wasn't the answer. And so sometimes prison isn't the answer. Especially in Georgia, our prisons are way overcrowded. We don't have room for everybody. And sometimes a judge will fashion a probation sentence that is restrictive.
But that's the judge. I mean, if you work out a deal that's, yes, signed off on the judge, but as a prosecutor, would you ever sign off on a deal where there is no prison time, even for felony abuse?
Yeah, I mean, it would happen all the time. There's a continuum. There was one day I think I was helping a friend out. I helped him take 7 pleas and 7 child abuse cases. And, the range went from one got reduced to a misdemeanor and one guy got sentenced to life. It was just all these different cases based on different facts. Not every case is a 20-year felony prison. We can't do that. It's just not possible. So there are factors.
I want to ask you about this statement from Big Blue Marble Academy. They fired Allen. Not a shocker there. And they released this statement, quote, "The safety of the young children in our care is our #1 priority. Therefore, we were deeply saddened to learn of the allegations against our former employee and acted swiftly to inform those affected in the teacher's classroom, reported the incident to local authorities, and conducted a thorough internal investigation, which resulted in the termination of their employment. We take these allegations very seriously and will continue to cooperate with local law enforcement and licensing authorities as the investigation continues." What do you make of that, Noah?
Yep. Yeah, they are licensed by a division they call it Bright from the start. And so there are certain regulations that they have to follow. So they will do an investigation to determine whether those regulations were followed, including the teacher-student-teacher ratio. Notifying all parents affected immediately is, I think, very important. We see in a lot of cases where that's not done, where it's not done for hours. There's another case in the news that happened earlier this year where a child was injured and the school didn't tell the parents. They figured it out on their own. And so, I think that there is an obligation not just to tell the parent of the affected child, but the other children in the class what happened. And you'd want that too if you were a parent and you were sending your child to a daycare.
I mean, the number one thing that comes out of these cases, answers. We need answers as to how this happened. Atlanta defense attorney Noah Pines, thank you so much for coming on. Really appreciate it.
Thank you.
All right, everybody, that's all we have for you right now here on Sidebar. Thank you so much for joining us. And as always, please subscribe on Apple Podcasts, Spotify, YouTube, wherever you get your podcasts. I'm Jesse Weber. Speak to you next time.